They were dead in the water, totally dead in the water. We had them dead to rights. The hospital clearly violated the standard of care, causing my client significant harm and injury. Did they fight us on that? The answer is, no, they didn't. You want to know what they did fight us on? Come join me for a walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It was so clear-cut what happened here. There was no doubt in anybody's mind that what occurred here was the hospital staff violated and departed from the standard of care. As a direct result of those violations from the standard of care, that carelessness, my client suffered harm and injury. So now, the defense called me up and said, hey, listen, we willingly acknowledge that our doctor and our hospital staff screwed up and caused your client injuries. What do you say we just go ahead and try this case on damages alone? You want to know what I said? Let's find out. I said, that's very interesting. I said, thank you for acknowledging and agreeing to the fact that you have absolutely no defense in this particular case. I want you to put into writing the fact that you have waived liability, that you acknowledge and you accept responsibility for liability, for being careless, and you accept the fact that this carelessness, your doctor's carelessness, was a cause of my client's injuries. And you know what they said? Yes, we will do that. We will go ahead and put in writing those two things. Now, why is that fascinating? It's fascinating because in these medical malpractice cases in New York, we are required to show three things. 1, 2, 3. We have to show, number one, that there was carelessness by the doctor or hospital staff. We have to show that the carelessness was a cause. It doesn't have to be the cause of my client's injuries, just a cause. And now that's number 2. And we have to show that my client's injuries are significant and or permanent. It can't just be something minor or temporary like a black and blue mark. It has to be significant. Now, all three of those things have to be confirmed by a medical expert who has reviewed all of the records and confirms each one of those things. By the defense turning around and telling me, listen, we will acknowledge the first thing, liability, that we were careless, and number 2, the second thing, what we call causation, that link between the carelessness and the injury. They will go ahead and acknowledge that. And that means that we no longer have to establish the second element that we need to show that we are slightly more likely right than wrong, that we are entitled to a verdict in our favor. So now, out of the 3 elements needed to prove a case, they've just eliminated the first 2. So the third one is to establish damages, that my client suffered significant harm and injury as a result of what they did. So now, they made an offer. And the offer was not to negotiate, but an offer to try this case, to go to trial, and now let a jury determine how much money my client is entitled to receive. That's what they were offering to do. So basically they're saying, listen, there's no need for a long, drawn-out litigation process here. We give up on the first 2 things you are required to prove. No need for long-winded depositions, no need to exchange all of these documents. Let's just go ahead and focus on your client's injuries, and let's find out whether she is as badly injured as you claim. Now, that's very tempting to turn around and say, sure, let's go ahead and do that. But there are drawbacks associated with that particular offer, and I'll tell you what they are. The first drawback is that if we focus only on my client's damages. Now, that's not a bad thing, but there are drawbacks to going ahead with that and agreeing to that strategy, and here they are. Let's assume we now focus on just my client's injuries. So what we are going to do is now we are obligated to give them copies of my client's medical records, which we have to do anyway. We have to give them permission slips, authorizations, so that the defense can obtain my client's records directly from her treating doctors and other hospitals, which we have to do anyway. Then they will want to go ahead and question my client in a deposition, in a question and answer session that's given under oath, where now they ask her hundreds and hundreds of questions about what problems she has now, what injury she suffered as a result of this wrongdoing, what things she can no longer do as a result of what occurred, and now they will probe her background as well, her medical background. They will want to see if there are any injuries that she suffered in the past that might have contributed to aggravating these particular injuries. And now the defense will do everything possible to whittle away the fact that my client suffered significant harm and injury. In all likelihood, they will also do video surveillance on her, hidden, secret video surveillance on her, to see if they can catch her in the act doing some of the activities she claims she cannot do, all designed to try and minimize the extent of her injuries. Now, one of the other drawbacks associated with this offer and this strategy that the defense is proposing is that once the case goes to trial, and the only issue to be decided at trial is not whether the doctor was careless, not whether the doctor's carelessness was a cause of my client's injury. They've given that up. And by leaving that information out, now the jury has only a limited view of what this case is really all about. Because if we agree to a trial just on damages, the jury is never told in detail exactly how my client wound up in this position. Yes, the jury will be told that the doctor and the hospital admit and acknowledge that they did something that caused my client these injuries. But beyond that, they will not be allowed to hear the details of exactly what was done wrong, why it was wrong, what they should have done instead, and how, had they done the correct things, my client never would have suffered these injuries. And that is a very, very powerful, motivating factor for a jury to consider when evaluating someone's injuries and damages. So although that offer sounds very enticing, to skip 2/3 of the entire litigation process and go right to a trial on damages, the reality is that it is fraught with drawbacks. And it is, in my opinion, a very significant drawback. Now, that's not to say that there aren't instances where we would agree to do that. But for the most part, it is not a great strategy for us as the injured victim, as the plaintiff going forward, to use, because it deprives the jury of learning about all the details associated with exactly what was done wrong, exactly why that wrongdoing caused and contributed to my client's injuries, and now they can see the full extent of what occurred to my client because of that specific carelessness. So, why do I share this with you? I share this with you to open your eyes, to help you understand that simply because the defense comes to us and says, listen, we agree that we are responsible for your client's injuries. We agree we did something wrong that never should have happened. Let's just have a trial on damages and move forward and avoid all the hassle and litigation associated with establishing all that. Let's just go straight to trial and focus on damages. Will you agree? As enticing as it sounds, my answer is no, we will not agree. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.